I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. And today we're talking intellectual property. Specifically, we're talking with Sharina, who will be talking about trademarks today. Sharina, why don't you introduce yourself and tell us a little bit more about you?
Sure. Thank you, Carrie, for having me, first of all. As you said, my name is Sharina Ankhi Krol. I'm the owner of Ankhi Krol Law, a law firm in Manhattan, in New York. I work with small businesses and also a lot of startups. And I work in the areas of business law, contract law, trademarks, and copyrights. So this is what I do, which is why Carrie decided to invite me to speak today. So once again, thank you, and thank you for listening.
So Sharina, let's first start with the basics. Help us understand the difference between different types of intellectual property, specifically trademarks, copyrights, and patents.
Sure. So they're actually completely different. A lot of times people come to me and they somehow think that they're the same, if not very similar, which is actually not correct. They're completely distinct and they serve separate purposes from each other. So let's start with trademark. A trademark protects the identity of your business. Now it has to be a business, right? It has to be a trade. The way I like to explain it to my clients or to my audience is, think of just the word trademark. It's the mark of your trade. So it would have to be a trade that you are associating with in order for trademark to be applicable. And then with copyright, once again, it's another play with words. If you look at the word copyright, it's basically the right to copy your own material. So it would have to be an original material that you have the authorship to, and that's also put in a tangible medium. So it can't just be in existence in your mind. There would have to be somewhere that is tangible, like a piece of paper, fabric, even these days on discs or on the computer, because if you're typing something up, you can eventually print that typed up material. So that's tangible in that matter. And then when we're looking at patents protect your ideas. And not anything else that we discussed. So that's how these three areas are different, just in a very basic way.
I love that. I never even thought about the word trademark or the word copyright like that before. So thank you for that. So what exactly can be trademarked?
So what can be trademarked? That's an excellent question. So your business name, your logo, if you have a slogan, or if there is a distinct look or feel. Now, what do I mean by the last one, the distinct look or feel? How many of you know of the Red Sole shoes? Carrie, do you know what I'm talking about?
Well, I'm going to probably mispronounce it. I'll say Louboutin, but I think that's an incorrect pronunciation.
Hey, at least people know what we're talking about, both of us. I'll probably mispronounce it too, so I won't even try. But that's exactly it. Those are the shoes that are famous for their soles. It's the red soles, and as soon as someone sees the red soles, they know exactly who the maker of the product is. So that's the distinct look or feel. You're not recognizing the brand by any name or slogan or logo. You're recognizing it by its distinct look and its feel, which is the red sole.
So it's pretty common, Sharina, for farms to include the last name. Like my parents' farm, for example, is called Rinker Simmentals, which is a breed of cattle, or Smith Family Farm. So can that brand name still be trademarked even though it includes the last name?
Yes, so your name can be trademarked as long as it's associated with a business. You cannot trademark your name if it's not associated with a business or a trade or a service. Let's say, I didn't have a business, my business, by the way, as you may already have guessed, I'm an attorney. So if I, didn't have this business, I wouldn't be able to trademark my name in the legal field if I wanted to. It's not trademarked right now. However, if I didn't have a business and I just wanted to trademark my name for the sake of it, I wouldn't be allowed to do that. I wouldn't be able to do that because it would just be my name at that point, and there wouldn't be any business associated with it. Let's go back to what I said earlier about trademark being the mark of your trade. So if you don't have a trade, you can't use a trademark.
That's a good point. So what's the difference between a word mark and a design mark? I've heard both of these terms.
Okay, so a word mark is basically just the word, a plain, simple word, any word, any name of a business that you may be thinking of. Let's take, for example, Starbucks. Everyone is familiar with that, I'm sure. So just the word Starbucks is a word mark. Now, if you look at their stylized version of the word Starbucks, that becomes a design mark. Or if you look at the logo of the mermaid that they have, that's a design mark. So you're looking at two separate things. You're looking at the logo and you're looking at a simple word.
What's the difference between a trademark and a service mark?
Okay, going back to exactly what I was saying before. We have described a trademark before, so now a service mark is the same thing. So it's the mark of your service. To give you an example that would be relatable would be FedEx, for example, right? So they're providing a service of delivering goods. They don't really have any goods of their own, so that's a service mark. However, when it comes to registering your trademark or service mark with the USPTO, it's the same form. So you wouldn't need to worry about, which one should I pick. You'll figure that out once you have to determine what it is that you're protecting.
So, Sharina, as I understand, when you file for a trademark, you have to pick a certain class of goods or services. And I'm just curious if you could speak a little bit more about that, and how do you choose which class or classes to apply for?
Sure. So the word class actually can be a little bit misleading, or it's not exactly self-explanatory. The whole way that the USPTO, the United States Patent and Trademark Office, classifies each item is through what is known as the international class. So there are hundreds of international classes. How I like to describe that is basically categories. So the USPTO has separated everything pretty much under the sun into categories and then subcategories. So if you are registering for, let's say, coffee, you won't also be protected for, let's say, computers. So you would have to have protection for those things that your business actually is involved in. So if I was in the coffee business, I could only register my mark for the coffee business, not also the computer business. However, if in the future I decided to move into the computer business as well, of course, at that point, I can try to amend it. Given that nobody else has that mark at that point in the computer industry, I would be able to get that mark under computers as well.
So I have a client who has a farm, and they offer different kinds of food products, and they have beef jerky and eggs and dairy and vegetables. Would this farm need to file trademarks in these various classes?
Yes. So there are two ways of filing for trademarks. So one is intent to use, which means your mark is not currently being used in commerce, meaning you're not currently in business for the things that you want to eventually use the name for. There's a second way of registering for a trademark, or applying for a trademark rather, and that is in use in commerce. So like what you just said, Carrie, if a farm is currently selling X, Y, and Z, you would be able to apply for those products, which would be, in various different categories or international classes, as we have just discussed.
So as I understand, you can actually file a trademark at either the state or the federal level. And I'm curious, when would you ever recommend to somebody that they would only file at the state level?
I actually wouldn't recommend that you only file at the state level, because then you're only really being protected within the state. So when you file federally, you're protected throughout the country on a federal level, which means better protection and also better remedy in case someone was to infringe on your mark.
Are there any prerequisites, though, in order to file at the federal level?
Not anything that's, different from the state level, really, but, each state may have its own separate ways of filing for a trademark. I don't really want to get into each state basis. However, the state level does not guarantee, as much protection to you as it would on a federal level. So I always recommend, if you're going to do one or the other, go with the federal level protection.
So I know there are some companies out there that will do professional searches for trademarks. Mm-hmm. And I'm curious on your thoughts on that. Like, do you recommend to your clients that they hire and do a professional search before filing?
I wouldn't only recommend a professional for search. I would also recommend a professional for filing. If you really know what you're doing, then by all means, you should be able to do the search and everything else on your own too. But yes, absolutely hire a professional to not just do the search, but also to do the filing for you, such as a trademark attorney that sees all the types of issues that may come up. Because if you don't, you're only really looking for problems that you are aware of. However, you can rest assured that there are issues that would come up that you had no idea about, because this would probably be your first or second application ever.
So I just want to be clear to the listeners that probably have no idea what I'm talking about. That professional search, and Sharina, please feel free to interject, basically helps make sure that before you file a trademark that you're not infringing or potentially infringing on somebody else's mark. And so these professional searches are basically scraped through the internet. They look through public records. Sharina, what are your thoughts there on that?
Yeah, so sometimes I have clients who come to me after they do their own search, and their own search really only goes through a Google search, right? Or something as preliminary as just looking at the USPTO's database of the names that are there, which are, helpful. However, it's not as in-depth as it would be if you hired a professional to do a search for you.
So give me some examples of what would be a red flag. Like if you were doing, if you had a client doing a search and something came up that was slightly different in the name, or maybe it sounded similar but wasn't exactly it. Like, what are some things that you're looking for as the attorney reviewer?
So at the end of the day, the main thing that you want to look for is whether the mark that you have is in the category that's in the same category as the one that the search is showing up. If they're in same or similar categories, then most likely you are not going to be getting the registration for your mark. However, I say most likely because the ultimate say is with the USPTO's examining attorney. So that once you file your application, within 3 months, an examining attorney is assigned to your file. So this attorney who works for the United States Patent and Trademark Office would do his or her own search and either decide that, okay, there are no conflicts, you can move forward, or there are conflicts, and these are the reasons why you should not be allowed registration of your mark. And then they will actually provide you with what is known as an office action that points out the reasons why you cannot obtain the registration. So that's what, a good search would prevent. If it's a good professional search that is thorough, you should be able to avoid such office actions.
Is there really a right time to file a trademark? I mean, do you have a general rule on that?
So if it's a very unique name that you pretty much came up with and you really can't live without, and you came up with this name even before you actually started selling your products or services, then I would say you should file for an intent to use application, which would basically reserve the name for the classes that you indicate in your application for about 6 months, and then you would have to provide proof that you are actually, in fact, using it the way that you claim. And if you are using it in that way, you would have to provide proof, and if the proof is accepted, at that point, they would, allow you registration.
So are there any...
if you,
Oh, go ahead. I'm sorry, Sheena.
No, I was just going to say, yeah, so if you really, really, really love a name and you really want to sort of just reserve it even before you start your business, then, file it as that. Otherwise, if you have a business name, I would recommend, filing for a registration as soon as you can, because it is a first come, first served basis. So the sooner you file, the better it is for you as far as protection. So let's say you file for something today, for any given class today, and I decide to file for the same class, in a week from now, you would be given preference over mine because you filed it first. Given, of course, that your actual use date was before mine.
Yeah, first in time, first in right. So, but are there any disadvantages in filing a trademark that you see?
Disadvantages, not really. The only thing you're doing is, you're putting the world on notice that you are using the name in the way that you state in your application. So if someone really wanted to, try to, infringe on your rights, knowing that you already have this mark, then they could potentially do it. However, by you not having the protection in place, you're risking even more, because I have seen people who start displaying in expos and, conferences, and they don't bother registering their name before they, have such mass viewing of their names or, their logos or slogans, and then other people decide to steal it and register it for themselves. So at that point, it becomes, a battle of he said, she said, who was first and this and that. And you end up spending a lot more money if you actually do decide to pursue it that late in the game.
Let's talk a little bit about the trademark process from start to finish, general rule. How long does it usually take?
So according to the USPTO site, it can take up to 18 months from the time that you put in your file to the time that they issue a registration. The quickest I have ever seen it has been 9 months from the time we filed until the time we got the certificate, and I've done hundreds of applications at this point. So, it's not an easy process, and a lot of times people confuse the trademark registration process with registering your business with the county. So they would come to me and they would say, oh, I already did it when I went over to the county clerk's office. And at that point that they actually didn't.
Right.
It's a time, it takes time to do the whole thing.
So excluding your fees or attorney's fees, what are the filing fees to file a trademark?
So there are separate ways of filing for a trademark. If you know what you're doing and you can do it in a very smooth, ultra way, you can pay $225 per category or international class, as we have discussed. Otherwise, I believe it is currently up to $375 if you don't know what you're doing and you kind of want help along the way and do it, like the easier way. It's $375 per class. So for me, for example, if you know what you're doing, you can save your clients money by doing it, the sleek way, because you know what you're doing. You don't need all that other, extra help or extra points. So, you can end up actually saving money if you speak to or work with a professional.
So, Sharina, we've all seen online like that little circle R or that little TM or that little SM. And so what do those mean exactly, and when can people start using them?
Sure. So the TM means trademark, SM means service mark, and the R in a little circle means registered. So you cannot use the R in a circle until you have been issued a registration number by the United States Patent and Trademark Office. However, if you have a business and you're using a certain mark, whether it be a word mark for a design mark, you can start putting your TM or your SM next to that mark as soon as you start using it, for your business.
Yeah. One time I had a client hand me over their specimen for a trademark, and it already had a circle R on it, Sharina. So I was like, oh, I think you need to take this off immediately because you can't use this yet. And also with the TM and the SM, sometimes I'm talking to food entrepreneurs or farmers, and they're like, oh, we need to file a trademark so we can get trademark rights. And something that I like to quickly explain to people is that you already have trademark rights. So you own your brand today. It's just not registered, which will strengthen those rights.
Correct. And also, by putting just TM or SM, what I have noticed after working with startups and small businesses for years now is that a lot of people actually go out looking for TMs and SMs so they can actually steal those names and go and register it. Can you believe that?
You're kidding me.
No, they actually, they're trolls, I guess you call it. So they actually go around and they look for TMs or SMs, and if they're not registered, apparently they just go ahead and try to register it on their own and then try to get money off of the owners by saying, okay, you can buy off of the trademark for this much or that much, So be very careful what you do.
So along those same lines, what should a company like a farmer, rancher, agribusiness do if they see some other business using their mark?
Well, first of all, you want to, approach them in a friendly way. You don't want to right away, as soon as you notice something, be angry or approach them in a bad manner. So what you want to do is keep a paper trail. Maybe send them a nice, friendly email saying, hey, I'm not sure if you're aware, but you are infringing on my registered trademark, and we would like for you to stop. So if they don't, you can escalate it to the next level by including an attorney in the mix. And if that doesn't work, the attorney can then obviously file for a lawsuit at the end of the day. That's your last resort.
I love that advice. I recently had an issue with a client, a cattle rancher, and the reason why we found out about another entity infringing on their mark was because I was trying to form an LLC for this entity, and it bounced back and said, hey, wait a second, you're conflicting with this other person's mark. And so I sent a cease and desist letter, but, they were very nice about it. They're like, we had no idea about your client, and my client had no idea about this other ranch who was using a similar brand name. And so, I guess I like to try to give people the benefit of the doubt at the very beginning that it wasn't done on purpose.
Right. And I think, niceness can really go a long way, because oftentimes people just aren't aware of what's out there, because whatever may have happened, maybe they didn't have time to look it up, or maybe they just didn't know that they should look up to see if there are any conflicts. So sometimes, from a friendly letter, allowing them to take something down without getting, an attorney involved may actually be helpful, not only financially because you're saving attorney fees, but it may just keep things, down low in a layman's term. So you just want to resolve it before it escalates to a point that they don't want to back down, and you end up spending, an arm and a leg in attorney's fees, or eventually end up in litigation.
Right. So what advice do you have to our listeners who are from coast to coast on how to find a trademark attorney who's going to help them through their business?
Sure. So like you have mentioned, Carrie, so trademarks can be filed on a federal level, and I do highly recommend that you do file it on a federal level. And that means you can actually hire an attorney anywhere in the country that, practices trademark law, because it's done on a federal basis. Any attorney that's licensed to practice law in any of the states would be able to help you. Now, how do you find an attorney that, is good for you, is suitable for you? First of all, ask your friends and relatives if they have had any good experiences with a certain attorney that they can recommend. If not, you can also, obviously Google someone's name. or just type in, trademark attorneys near me or best trademark attorney, something to that effect. And then you can do your online research that way. And then, if you have a chance, speak to them on the phone really quickly to see, what kind of feeling you get after speaking to them. And if you like them, and at that point, you can just, start working with them and see where it goes.
So when people are interviewing trademark lawyers, what are some quick tips of questions that they should be sure to ask?
Sure. So something you can ask them is, how long have you been doing it? Is this something that you handle on your own, or does your associate handle everything? So that way you know exactly who would be in charge of filing your application. Now, something that some people ask me, and I don't really like that question, is, can you give me names of your clients? Which, it's kind of not my taste to give out my clients' names, although this is public information. Once you file your trademark application, your name and your attorney's name will become public information because it will be posted on the United States Patent and Trademark Office. However, I do not give that information out over the phone. So don't ask that question. Don't ask personal questions like that, because it may not be a good way for you to even figure out, how the attorney works. So it will only tell you who they're working for or who they have worked for, but it doesn't really tell you how they work. So you really have to figure out how they work.
I agree, Shrina. I hate that question. I just feel like it's just, everybody that I work for, this is confidential and this is privileged. So don't ask me to give you my client list.
Right. And then, like I said, when you're doing your Google search, you should be able to see reviews, and these reviews are from clients. So you can get an idea of who they have worked for. And, if you're really interested in figuring out, who they have worked for, you can probably go on the USPTO site and poke around. But that's really a waste of time, because whoever an attorney worked for in the past really has nothing to do with, whether or not they're good for you. What you need to know is how they work and, what their fees are and how their personality is, if it meshes with yours and things like that. So keep it personal to you and not to anyone else.
Thanks, Shrina. And how can people contact you if they're interested in having a conversation about trademarks?
Sure. So you can always look up all my information on my website, which is ankhikrol.com. That's ANKHIKROLLAW.com. Or you can simply call me, 212-729-6153. And my email and all my social media information should be on my website as well.
Thanks, Shrina. I really appreciate your time and expertise on this subject.
Thank you, Carrie.
All right. Next up on the Ask Carrie portion of the podcast, and this comes from a food entrepreneur in upstate New York. She writes, "Can I copyright a food recipe?" Well, so let's talk a little bit about what can you copyright. And in order to have a copyright, then you must have, quote, an original work of art authorship in any tangible medium of expression. And that's under the Copyright Act at the federal level. And what in the world does all that legalese mean? Well, here are some examples. We're referring to original literary works, books, for example. I've written 2 books and they're both copyrighted with the U.S. Copyright Office. Musical works, I'm definitely not musical, but if I ever came up with my own jingle, I'd be sure to copyright it. Dramatic works, pictures, so photographers, graphic works, motion pictures, sound recordings. These are all things that are, quote, original works of authorship. All right, so what does that exactly mean as it applies to recipes? So copyright protection does not protect an idea, a procedure, a process, system, a method of operation, concept, principle, or discovery. So what is a recipe? Well, it's in simplest form, a recipe is just a list of ingredients alone, and that is not copyrightable. But if you add add to that list of ingredients a set of instructions, some explanations, perhaps some stories of how you used to make this with your grandmother, some photographs, and compile that in a cookbook, that is copyrightable. For those of you that are listening and thinking, well, what am I going to do about my magical cookies or my barbecue sauce that has a special recipe? Well, for those of you that are concerned about employees perhaps taking that secret ingredient, then you can just have those employees or independent contractors sign a confidentiality agreement. And I hope to discuss that in more detail at a podcast to come. If you have a question for me for the Ask Carrie podcast, be sure to email me at Carrie, Cari, at rinkerlaw.com, spelled RINCKERLAW.com.